Welcome to this episode of the Montpelier Happy Hour here on WVEW 107.7 LP Brattleboro, your community radio station. I am your host, and this is the show where we talk about how things in Montpelier shake out for the rest of us. And this episode, we are talking about the biggest piece coming out of Montpelier that shakes out for the rest of us, and that is the Constitution of the state of Vermont. Regular contributor and representative Emily Kornheiser, would you please enlighten our listeners as to why we are going to read them the lovely Constitution of the state of Vermont?
Absolutely. Thanks, Olga, and good to spend this time with you. So if we spent a lot of time talking about lessons learned from the pandemic. And one of the lessons that I learned from the pandemic, and I think a lot of other people learned, was the value and necessity of rest. And so Olga and I deserve rest just as much as everyone else. And one of my favorite podcasts, and I love it when podcasts reference other podcasts, is called The Memory Palace. And he does these incredibly gentle, deep dives into historic moments. He tells about these singular historic moments as if they're the most charming stories. Some of them are heartbreaking, and I found myself sobbing in the car, and some of them I laugh out loud. And anyway, it's an incredible podcast, very much outside of time and space. Highly recommend it. But one thing that he is doing this August that he's never done before, usually he just sort of airs some reruns to keep up with his schedule, is he did 3 episodes recording himself reading The Great Gatsby, actually, which I've read myself before, but I really have enjoyed listening to him read. So was thinking about our need for rest, how things in Montpelier shake out for the rest of us. So many conversations that I've been having lately with the Pupil Waiting Study and with Education Finance and the Brigham decision and Vermont's Constitution, and how much it informs everything we do and how little time we actually spend reading it or talking about it. And so we wanted today to read you the Constitution of the state of Vermont, and we will air this next week while we are all off resting. The Constitution of the state of Vermont was established July 9th, 1793, and the version that we're reading you was amended through November 2nd, 2010. As listeners might know, we have been working on amending the Constitution further, and we have a few constitutional amendments that went through their first round of votes in order to go through a constitutional amendment process, but they still need to go through a second biennium of voting, which we're actually going to do this winter, and then they go on a referendum to the voters. And we'll actually hear about that way further down in the Constitution. There's parts in the Constitution about how you amend the Constitution. So without further ado, during our time of rest, we offer to you the Constitution of the state of Vermont. Chapter 1, a declaration of the rights of the inhabitants of the state of Vermont. Article 1, all persons born free, their natural rights, slavery prohibited. That all persons born equally free and independent and have certain natural, inherent, and unalienable rights, amongst which are the enjoying and defending life and liberty, acquiring, possessing, and protecting property, and pursuing and obtaining happiness and safety. Therefore, no person born in this country or brought from overseas ought to be holden by law to serve any person as a servant, slave, or apprentice after arriving to the age of 21 years, unless bound by the person's own consent after arriving to such age, or bound by law for the payment of debts, damages, fines, costs, or the like.
Article 2, private property subject to public use, owner to be paid. That private property ought to be subservient to public uses when necessary requires it. Nevertheless, whenever any person's property is taken for the use of the public, the owner ought to receive an equivalent in money.
Article 3, freedom in religion, right and duty of religious worship. That all persons have a natural and unalienable right to worship Almighty God, according to the dictates of their own consciences and understandings, as in their opinion shall be regulated by the word of God, and that no person ought to, or of right, can be compelled to attend any religious worship, or erect or support any place of worship, or maintain any minister, contrary to the dictates of conscience, nor can any person be justly deprived or abridged of any civil right as a citizen, on account of religious sentiments, or peculiar modes of religious worship, and that no authority can or ought to be vested in or assumed by any power whatever that shall in any case interfere with or in any manner control the rights of conscience in the free exercise of religious worship. Nevertheless, every sect or denomination of Christians ought to observe the Sabbath or Lord's Day and keep up some sort of religious worship, which to them shall seem most agreeable to the revealed will of God.
Article 4. Remedy at law secured to all. Every person within the state ought to find a certain remedy by having recourse to the laws for all injuries or wrongs which one may receive in person, property, or character. Every person ought to obtain right and justice freely and without being obtained to purchase it, completely and without any denial, promptly and without delay, conformably to the laws.
Article 5, Internal Police. That the people of the state, by their legal representatives, have the sole, inherent, and exclusive right of governing and regulating the internal police of the same.
Article 6. Officers, servants of the people. That all power being originally inherent in and consequently derived from the people, therefore, all officers of government, whether legislative or executive, are their trustees and servants, and at all times, in a legal way, accountable to them.
Article 7, Government for the people. They may change it. That government is or ought to be instituted for the common benefit, protection, and security of the people, nation, or community, and not for the particular emolument, or advantage of any single person, family, or set of persons who are part only of that community, and that the community hath an indubitable, unalienable, and indefeasible right to reform or alter government in such a manner as shall be by that community judged most conducive to the public wealth.
Article 8. Elections to be free and pure, rights of voters therein. That all elections ought to be free and without corruption, and that all voters, having a sufficient, evident common interest with and attachment to the community, have a right to elect officers and be elected into office, agreeably to the regulations made in this Constitution.
Article 9, Citizens' rights and duties in the state, bearing arms, taxation. That every member of society hath a right to be protected in the enjoyment of life, liberty, and property, and therefore is bound to contribute to the members' proportions towards the experience of that protection, and yield personal service when necessary or an equivalent thereto, but no part of any person's property can be justly taken or applied to public uses without the person's own consent or that of the representative body. Nor can any person who is conscientiously scrupulous of bearing arms be justly compelled thereto, if such person will pay such equivalent, nor are the people bound by any law, such as they have in like manner assented to, for their common good. And previous to any law being made to raise a tax, the purpose for which it is to be raised ought to appear evident to the legislature to be of more service to community than the money would be if not collected.
Article 10. Rights of persons accused of crime, personal liberty, waiver of jury trial. That in all prosecutions for criminal offenses, a person hath a right to be heard by oneself and by counsel, to demand the cause and nature of the accusation, to be confronted with the witnesses, to call for evidence in the person's favor, and a speedy public trial by an impartial jury of the country, without an ununanimous consent of which jury the person cannot be found guilty, nor can a person be compelled to give evidence against oneself, nor Can any person be justly deprived of liberty except by the laws of the land or the judgment of the person's peers, provided, nonetheless, in criminal prosecutions for offenses not punishable by death, the accused, with the consent of the prosecuting officer entered of record, may in open court or by a writing signed by the accused and filed with the court, waive the right to a jury trial and submit the issue of the accused's guilt to the determination and judgment of the court without a jury.
Article 11, search and seizure regulated. That the people have a right to hold themselves, their houses, papers, and possessions free from search and seizure, and therefore warrants without oath or affirmation first made affording sufficient foundation for them, and whereby any officer or messenger may be commanded or required to search suspected places or to seize any person or persons, his, her, or their property, not particularly described or contrary to that right and ought not to be granted.
Article 12, trial by jury to be held sacred. That when any issue in fact proper for the cognizance of a jury is joined in a court of law, the parties have a right to trial by jury, which ought to be held sacred.
Article 13, freedom of speech and of the press. That the people have a right to freedom of speech and of writing and publishing their sentiments concerning the transactions of government, and therefore the freedom of the press ought not to be restrained.
Article 14, immunity for words spoken in legislative debate. The freedom of deliberation, speech, and debate in the legislature is so essential to the rights of the people that it cannot be the foundation of any accusation or prosecution, action, or complaint in any other court or place whatsoever.
Article 15, legislature only may suspend laws. The power of suspending laws or the execution of laws ought never to be exercised but by the legislature or by authority derived from it to be exercised in such particular cases as this Constitution or the legislature shall provide for.
Article 16, right to bear arms, standing armies, military power, subordinate to civil. That the people have a right to bear arms for the defense of themselves and the state, and as standing armies in time of peace are dangerous to liberty, they ought not to be kept up, and that the military should be kept under strict subordination to and governed by the civil power.
Article 17, martial law restricted. That no person in the state can in any case be subjected to law martial or to any penalties or pains by virtue of that law, except those employed in the army and the militia in actual service.
Article 18, regard to fundamental principles and virtues necessary to preserve liberty. That frequent recurrence to fundamental principles and a firm adherence to justice, moderation, temperance, industry, and frugality are absolutely necessary to preserve the blessings of liberty and keep government free. The people ought, therefore, to pay particular attention to these points in the choice of officers and representatives, and have a right in a legal way to exact a due and constant regard for them from their legislators and magistrates in making and executing such laws as are necessary for the good government of the state.
Article 19, right to emigrate. That all people have a natural and inherent right to emigrate from one state to another that will receive them.
Article 20, right to assemble, instruct, and petition. That the people have a right to assemble together to consult for their common good, to instruct their representatives, and to apply to the legislature for redress of grievances by address, petition, or remonstrance.
Article 21, no transportation for trial. That no person shall be liable to be transported out of the state for trial for any offense committed within the same.
Chapter 2, Plan or Frame of Government, Delegation and Distribution of Powers. 1. Governing Power. The Commonwealth or State of Vermont shall be governed by a governor or lieutenant governor, a Senate and a House of Representatives in manner and form following. Supreme legislative power, number 2. The supreme legislative power shall be exercised by a Senate and a House of Representatives.
3. Supreme executive power. The supreme executive power shall be exercised by a governor, or in the governor's absence, a lieutenant governor.
4. Judiciary. The judicial power of the state shall be vested in a unified judicial system, which shall be composed of a Supreme Court, a Superior Court, and such other subordinate courts as the General Assembly may from time to time obtain and establish.
5. Departments to be distinct. The legislative, executive, and judiciary department shall be separate and distinct so that neither exercise the powers properly belonging to the others.
Legislative Department. 6. Legislative powers. The Senate and the House of Representatives shall be styled the General Assembly of the State of Vermont. Each shall have and exercise the like powers in all acts of legislation, and no bill, resolution, or other thing which shall have been passed by the one shall have the effect of or be declared to be a law without the concurrence of the other, provided that all revenue bills shall originate in the House of Representatives, but the Senate may propose or concur in amendments as on other bills. Neither house during the session of the General Assembly shall, without the consent of the other, adjourn for more than 3 days, nor to any other place than that in which the two houses shall be sitting, and in case of disagreement between the two houses with respect to adjournment, the governor may adjourn them to such time as the governor shall think proper. They may prepare bills and enact them into laws, redress grievances, grant charters of incorporation, subject to the provisions of Section 69, constitute towns, boroughs, cities, and counties, and they shall have all other powers necessary for the legislature to be legislature of a free and sovereign state. But they shall have no power to add to, alter, abolish, or infringe any part of this Constitution.
7. Biennial sessions. The General Assembly shall meet biennially on the first Wednesday next after the first Monday of January, beginning AD 1915.
8. Doors of General Assembly to be open. The doors of the house in which the General Assembly of this Commonwealth shall sit shall be open for the admission of all persons who behave decently, except only when the welfare of the state may require them to be shut.
9. Journals, yeas and nays. The votes and proceedings of the General Assembly shall be printed when 1/3 of the members of either house think it necessary, as soon as convenient after the end of the session, with the yeas and nays of the House of Representatives on any question when required by 5 members, and of the Senate when required by 1 senator, except where the vote shall be taken by ballot, in which case every member of either house shall have a right to insert the reasons of the member's vote upon the minutes.
10. Style of laws. This style of the laws of this state shall be, it is hereby enacted by the General Assembly of the State of Vermont.
11. Governor to approve bills, veto proceedings thereon, non-action. Every bill which shall have passed the Senate and House of Representatives shall, before it becomes a law, be presented to the governor. If the governor approve, the governor shall sign it. If not, the governor shall return it with objections in writing to the house in which it shall have originated, which shall proceed to reconsider it. If, upon such reconsideration, 2/3 of the members present of the House shall pass the bill, it shall, together with the objections, be sent to the other House, by which it shall likewise be reconsidered. and if approved by 2/3 of the members present of that House, it shall become a law. But in all such cases, the votes of both houses shall be taken by yeas and nays, and the names of the person voting for or against the bill shall be entered on the journal of each house respectively. If any bill shall not be returned to by the governor, as aforesaid, within 5 days, Sundays excepted, after it shall have been presented to the governor, the same shall become a law in like manner as if the governor had signed it, unless the two houses, by their adjournment, within 3 days after the presentation of such bill shall prevent its return, in which case it shall not become a law.
12. Fees for advocating bills, etc. No member of the General Assembly shall, directly or indirectly, receive any fee or reward to bring forward or advocate any bill, petition, or other business to be transacted in the legislature, or advocate any cause as counsel in either house of legislation, except when employed in behalf of the state.
13. Representatives, number. The House of Representatives shall be composed of 150 representatives. The voter of each representative district established by law shall elect 1 or 2 representatives from that district, the number from each district to be established by the General Assembly. In establishing representative districts which shall afford equality of representation, the General Assembly shall seek to maintain geographical compactness and contiguity, and to adhere to boundaries of counties and other existing political subdivisions.
14. Powers of House. The representatives so chosen, a majority of whom shall constitute a quorum by transacting any other business than raising a state tax, for which 2/3 of the members elected shall be present, shall meet as required by Section 7, and shall be styled the House of Representatives. They shall have power to choose their speaker, their clerk, and any other necessary officers, sit on their own adjournment subject to the limitations of Section 6, judge of the elections and qualifications of their own members. They may expel members, but not for causes known to their constituents antecedent to their election, administer oaths and affirmations in matters depending before them, and impeach state criminals.
15. Residence of representatives and senators. No person shall be elected a representative or a senator until the person has resided in the state 2 years, the last year of which shall be in the legislative district for which the person is elected.
16. Representatives' oath.
The representatives, having met and chosen their speaker and clerk, shall each of them, before they proceed to business, take and subscribe, as well as the oath or affirmation of allegiance hereinafter directed, except where they shall produce certificates of their having theretofore taken and subscribed the same as the following oath or affirmation. You do solemnly swear or affirm that as a member of this assembly, you will not propose or assent to any bill, vote, or resolution which shall appear to you injurious to the people, nor consent to any act or thing whatever that shall have a tendency to lessen or abridge the rights and privileges as declared by the Constitution of this state, but will in all things conduct yourself as a faithful, honest representative and guardian of the people, according to the best of your judgment and ability, in case of an oath, so help you God, or in case of an affirmation under the pains and penalties of perjury.
17. Oath of Senators and Representatives. The representatives having met on the day appointed by law for the commencement of a biennial session of the General Assembly and chosen their speaker, and the senators having met, shall, before they proceed to business, take and subscribe the following oath, in addition to the oath prescribed in the foregoing section. Do you solemnly swear or affirm that you did not at the time of your election to this body, and that you do not now hold any office of profit or trust under the authority of Congress, so help you God, or in the case of an affirmation, under the pains and penalties of perjury? The words office of profit or trust under the authority of Congress shall be construed to mean any office created directly or indirectly by Congress and for which emolument is provided from the Treasury of the United States, other than that of a member of the commissioned or enlisted personnel in reserve components of the armed forces of the United States while not on extended active duty. And with that, the Montpelier Happy Hour on WVEW 107.7 LP Brattleboro, your community radio station, will take a moment to hear from its underwriters. Stay tuned. Welcome back to the second half of this special episode of the Montpelier Happy Hour on WVEW 107.7 LP Brattleboro, your community radio station. Today, we are reading you the Constitution of the state of Vermont as a moment of rest, as a moment of contemplation, and as Emily and I are discovering as we go through the Constitution, not only a vocabulary test, but many things about our state that we did not know before. So thank you for joining us today. We are currently reading Chapter 2, Plan or Frame of Government, Delegation and Distribution of Powers. Emily.
Subsection 18, Senators, Numbers, Qualifications. The Senate shall be composed of 30 senators to be of the senatorial district from which they are elected. The voters of each senatorial district established by law shall elect one or more senators from that district, the number from each district to be established by the General Assembly. In establishing senatorial districts, which shall afford equality of representation, the General Assembly shall seek to maintain geographical compactness and contiguity, and to adhere to boundaries of counties and other existing political subdivisions.
Subsection 19, Powers of Senate, Lieutenant Governor's duties. The Senate shall have the like powers to decide on the election and qualifications of, and to expel any of, its members, make its own rules, and appoint its own officers, as are incident to, or are possessed by, the House of Representatives. A majority shall constitute a quorum. The lieutenant governor shall be president of the Senate, except when exercising the office of governor, or when the office of the lieutenant governor shall be vacant, or in the absence of the lieutenant governor, in which cases the Senate shall appoint one of its own members to be president of the Senate pro tempore, and the president of the Senate shall have a casting vote, but no other.
Executive Department. 20. Governor, executive power. The governor, and in the governor's absence, the lieutenant governor, shall have power to commission all officers and also to appoint officers, except where provision is or shall be otherwise made by law or this frame of government, and shall supply every vacancy in any office occasioned by death or otherwise until the office can be filled in the manner directed by law or this Constitution. The governor is to correspond with other states, transact business with officers of government, civil and military, and prepare such business as may appear necessary to lay before the General Assembly. The governor shall have power to grant pardons and remit fines in all cases whatsoever, except in treason, in which the governor shall have power to grant reprieves, but not to pardon until after the end of the next session of the General Assembly, and except in cases of impeachment, in which the governor shall not grant reprieve or pardon, and there shall be no remission or mitigation of punishment, but by act of legislation. The governor is also to take care that the laws be faithfully executed. The governor is to expedite the execution of such measures as may be resolved upon by the General Assembly, and the governor may draw upon the Treasury for such sums as may be appropriated by the General Assembly. The governor may also lay embargoes or prohibit the exportation of any commodity for any time not exceeding 30 days in the recess of the General Assembly only. The governor may grant such licenses as shall be directed by law, and shall have power to call together to the General Assembly when necessary before the day to which they shall stand adjourned. The governor shall be captain general and commander-in-chief of the forces of the state, but shall not command in person in time of war or insurrection, unless by the advice and consent of the Senate, and no longer than they shall approve thereof. And the lieutenant governor shall, by virtue of office, be lieutenant general of all the forces of the state.
21. Secretary of Civil and Military Affairs. The governor may have a Secretary of Civil and Military Affairs to be appointed during pleasure, whose services the governor may at all times command, and for whose compensation provisions shall be made by law.
22. Commissions, state seal. All commissions shall be in the name of the people of the state of Vermont, sealed with the state seal, signed by the governor, and in the absence of governor by the lieutenant governor, and attested by the secretary, which seal shall be kept by the governor.
23. Residence of governor and lieutenant governor. No person shall be eligible to the office of governor or lieutenant governor until the person shall have resided in this state 4 years next preceding the day of election.
24. Vacancy in office of governor, lieutenant governor, and treasurer. The legislature shall provide by general law what officer shall act as governor whenever there shall be a vacancy in both the offices of governor and lieutenant governor, occasioned by failure to elect, or by the removal from office, or by the death or resignation of both governor and lieutenant governor, or by the inability of both governor and lieutenant governor to exercise the powers and discharge the duties of the office of governor. And such officer so designated shall exercise the powers and discharge the duties appertaining to the office of governor accordingly until the disability shall be removed or governor shall be elected. And in case there shall be a vacancy in the office of treasurer by reason of any of the cases enumerated, the governor shall appoint a treasurer for the time being, who shall act as treasurer until the disability shall be removed or a new election shall be made.
25. Security given by treasurer and sheriffs. The treasurer of the state shall, before entering upon the duties of office, give sufficient security to the Secretary of State in behalf of the state of Vermont before the governor of the state or one of the justices of the Supreme Court, and sheriffs, before entering upon the duties of their office, shall give sufficient security in such manner and in such sums as shall be directed by the legislature.
26. Treasurer's accounts. The treasurer's account shall be annually audited, and a fair state thereof laid before the General Assembly at its biennial session in January.
27. Drawing money from treasury. No money shall be drawn out of the treasury unless first appropriated by act of legislation.
Judiciary Department. 28. Courts of Justice. The courts of justice shall be open for the trial of all causes proper for their cognizance, and justice shall be therein impartially administered without corruption or unnecessary delay.
29. The Supreme Court composition. The Supreme Court shall consist of the Chief Justice of the state and 4 associate justices of the Supreme Court.
30. Supreme Court jurisdiction. The Supreme Court shall exercise appellate jurisdiction in all cases, criminal and civil, under such terms and conditions as it shall specify in rules not inconsistent with law. The Supreme Court shall have original jurisdiction only as provided by law, but it shall have the power to issue all writs necessary or appropriate in aid of its appellate jurisdiction. The Supreme Court shall have administrative control of all the courts of the state and disciplinary authority concerning all judicial officers and attorneys at law in the state.
31. Lower courts jurisdiction. All other courts of this state shall have original and appellate jurisdiction as provided by law. All courts except the Supreme Court may be divided into geographical and functional divisions as provided by law or by judicial rules adopted by the Supreme Court not inconsistent with law. The jurisdiction of geographical and functional divisions shall be as provided by law or by judicial rules not inconsistent with law. The courts of the state may exercise equity jurisdiction as well as law jurisdiction, in civil proceedings as may be provided by law or by judicial rules not inconsistent with law.
32. Filling judicial vacancies. The governor, with the advice and consent of the Senate, shall fill a vacancy in the office of the Chief Justice of the State, Associate Justice of the Supreme Court, or Judge of any other court, except the office of Assistant Judge and of Judge of Probate from a list of nominees presented by a judicial nominating body established by the General Assembly having authority to apply reasonable standards of selection.
33. Interim judicial appointments. When the Senate is not in session, the governor may make an interim appointment to fill a vacancy in the office of Chief Justice, Associate Justice of the Supreme Court, or Judge of any other court, except the office of Assistant Judge and of Judge of Probate, from a list of nominees presented by the judicial nominating body. A justice or a judge so appointed shall hold office with all the powers incident to the office until the Senate convenes and acts upon the appointment submitted by the governor. Thereafter, the appointee shall continue in office if the Senate consents to the appointment. If the appointment is not confirmed upon vote of the Senate, the appointment shall be terminated and a vacancy in the office will be created.
34. Judicial term of office. The justices of the Supreme Court and judges of all subordinate courts, except assistant judges and judges of probate, shall hold office for terms of 6 years, except when holding office under an interim appointment. At the end of the initial 6-year term and at the end of each 6-year term thereafter, such justice or judge may give notice in the manner provided by law of a desire to continue in office. When such justice or judge gives the required notice, the question of continuance in office shall be submitted to the General Assembly, and the justice or judge shall continue in office for another term of 6 years unless a majority of the members of the General Assembly voting on the question vote against continuation in office.
35. Mandatory retirement. All justices of the Supreme Court and judges of all subordinate courts shall be retired at such age, not less than 70 years of age, as the General Assembly may prescribe by law, or if the General Assembly has not so provided by law, at the end of the calendar year in which they attain 70 years of age, or at the end of the term of election during which they attain 70 years of age, as the case may be, and shall be pensioned as provided by law. The Chief Justice may, from time to time, appoint retired judges and justices to special assignments as permitted under the rules of the Supreme Court.
36. Suspension and removal implementation procedures for sections 32 through 36. The justices of the Supreme Court and the judges of all subordinate courts shall hold office during good behavior for the terms for which they are appointed. The Supreme Court, in the exercise of its disciplinary power over the judiciary of the state, may suspend justices of the Supreme Court and judges of all subordinate courts from the judicial function for such cause, and in such manner as may be provided by law. The General Assembly may establish procedures for the implementation of the provisions of sections 32 through 36.
37. Rule-making power. The Supreme Court shall make and promulgate rules governing the administration of all courts, and shall make and promulgate rules governing practice and procedure in civil and criminal cases in all courts. Any rule adopted by the Supreme Court may be revised by the General Assembly.
38. Jury trials. Trials of issues proper for the cognizance of a jury as established by law or by judicial rules adopted by the Supreme Court not inconsistent with law in the Supreme Court, the Superior Court, and other subordinate courts shall be by jury except where parties otherwise agree, and great care ought to be taken to prevent corruption or partiality in the choice and return of the or appointment of juries.
39. Forms of prosecutions and indictments, fines. All prosecutions shall commence by the authority of the state of Vermont. All indictments shall conclude with these words, against the peace and dignity of the state, and all fines shall be proportioned to the offenses.
40. Excessive bail prohibited, prisoners bailable, imprisonment for debt prohibited. Excessive bail shall not be exacted for bailable offenses. All persons shall be bailable by sufficient sureties except as follows. A person accused of an offense punishable by death or life imprisonment may be held without bail when the evidence of guilt is great. 2. A person accused of a felony, an element of which involves an act of violence against another person, may be held without bail when the evidence of guilt is great and the court finds, based upon clear and convincing evidence, that the person's release poses a substantial threat of physical violence to any person, and that no condition or combination of conditions of release will reasonably prevent the physical violence. A person held without bail to trial under this paragraph shall be entitled to review de novo by a single justice of the Supreme Court forthwith. 3. A person awaiting sentence or sentenced pending appeal may be held without bail for any offense. A person held without bail prior to trial shall be entitled to review of that determination by a panel of 3 Supreme Court justices within 7 days after bail is denied, except in the case of an offense punishable by death or life imprisonment. If a person is held without bail prior to trial, the trial of the person shall be commenced not more than 60 days after the bail is denied. If the trial is not commenced within 60 days and the delay is not attributable to the defense, the court shall immediately schedule a bail hearing and shall set bail for the person. No person shall be imprisoned for debt.
41. Habeas corpus. The writ of habeas corpus shall in no case be suspended. It shall be a writ issuable of right, and the General Assembly shall make provision to render it a speedy and effectual remedy in all cases proper therefore. Qualifications of free men and free women.
42. Voters' qualifications and oath. Every person of that full age of 18 years who is a citizen of the United States, having resided in this state for the period established by the General Assembly, and who is of a quiet and peaceable behavior and will take the following oath or affirmation, shall be entitled to all the privileges of a voter of this state. You solemnly swear or affirm that whenever you give your vote or suffrage touching any matter that concerns the state of Vermont, you will do it so as in your conscience you shall judge will most conduce to the best good of the same, as established by the Constitution, without fear or favor of any person. Every person who will attain the full age of 18 years by the date of the general election, who is a citizen of the United States, having resided in this state for the period established by the General Assembly, and who is of a quiet and peaceable behavior, and will take the oath or affirmation set forth in this section, shall be entitled to vote in the primary election.
Thank you for joining us for this episode of the Montpelier Happy Hour here on WVEW 107.7 LP Brattleboro, your community radio station. As always, you can find us at Emily's YouTube channel, our Facebook page, our Montpelier Happy Hour.captivate.fm page, BCTV, and wherever you find your podcasts. Thank you for joining us.